Supreme Court judgment, in fact, on the EVM and the VVPAT has been reserved. Remember, this petition has been going on and hearing continues on this. The court has now reserved its judgment as far as the VVPAT is concerned. The petitioners, it was a batch of petitions which had gone to the Supreme Court asking for 100% counting of the VVPAT, slips. Remember, the Supreme Court has been hearing this. There have been few hearings which have already taken place as far as this is concerned. Today, in fact, hearing in the Supreme Court, the court said that so far there is no, I beg your pardon, evidence of EVM tampering, and should the court only act on mere suspicion. The Election Commission also in the court submitted today that the control units, the polling data is all sealed during the commissioning. All three units are also sealed with a pink seal. The VVPAT is sealed and the signature is taken from all polling agents before this entire process is done. Meanwhile, Justice Khanna also, in fact, speaking on this, said that if there is something to improve, we can certainly improve. Courts intervened twice. Once when we said VVPAT should be mandatory, and second when we increased from 1 to 5. Let me go across to my colleague Aishwarya, who is joining us with more details on this. Aishwarya, important hearing going on. Now the order has been reserved. What have been the highlight today?
Well, certainly today was the day when the judgment was about to come. The directions from the Supreme Court over the petition that was filed by the ADR, in which they clearly had sought 100% verification of the VVPATs through EVM. But today, as the two-judge bench they clearly first stated that they wanted some clarification from the Election Commission of India, and therefore the technical team officer was summoned of the Election Commission of India at 2 p.m. to which answers were sought as far as the microcontroller chip is concerned, where it is placed, for how much duration this microcontroller chip has the storage capacity of, whether this is a one-time programmed or this can be reused again and again, after which it was the answers were given to the Supreme Court. The clarification was made by the Election Commission of India and stated that the time period that anyone can file plea on the results of election if they need to challenge is a time period of 45 days, and the Supreme Court stated that whether this chip has 60 days of time period, so that if anyone can approach the High Court or registrars, then these chips can be reopened, to which the Election Commission of India clarified to the Supreme Court that once they get a nod from the registrars all across the country, then only these chips are sent to the sealed rooms, and that they get sealed. Ultimately, it was one on microcontroller. The observation was seen. The second was on the microcontrollers, whether this one-time program or it can be used again. Justice Khanna at this point of at that point clearly stated that after counting, all machines are stored for 45 days. On 46th day, in fact, we write to the respective high courts, registrars, and response to do the needful, and later the sealing of EVM happens. After hearing all of these arguments from the Election Commission of India, it was stated by the Supreme Court that once we had already intervened in the matter from 5%, whether we can increase the counting of VVPATs to more than that is something that we will keep in eye when we will be writing down the directions. But certainly at this point of time, the order has been reserved for the upcoming time period, and we'll get to know what Supreme Court thinks of all of these arguments from the Election Commission of India.
Thank you, Aishwarya, for joining us with all those details.